Good evening. My name is Dana Bowen Matthew. I have the privilege of being the Dean of George Washington University Law School. I am ecstatic to welcome you to the fourth installment of our historic five-part series of conversations focusing on the life and distinguished career of recently retired U.S. Supreme Court Justice Stephen G. Breyer. This is an only at GW moment, a series of exclusive interviews begun last year, and it creates a comprehensive oral history of the arc of a great jurist's career. This historic series would not have been possible without the vision and tireless efforts of Dean Alan Morrison, who has been a good friend of Justice Breyer's for more than 40 years. Thank you, Alan, for bringing this wonderful program to our law school. I also want to extend my sincere gratitude and a very warm welcome to Justice Breyer and today's moderator, our very own Bob Braunice, the Michael G. McKeon Professor of Intellectual Property Law. It's now my great honor to introduce Professor Braunice, who served as a law clerk for Justice Breyer during his time on the United States Court of Appeals for the First Circuit. Professor Braunice will interview the justice about his years as a circuit judge, as well as his work on the commission that wrote the federal sentencing guidelines. Professor Braunice, an internationally recognized scholar in the areas of copyright law, trademark law, constitutional law, and artificial intelligence, truly exemplifies what it means to be a distinguished professor at the George Washington University Law School. He joined GW Law's faculty in 1993, where for the past 30 years he has given his time, talent, and strength to the law school's IP program. Strength because we're really highly ranked. I guess that's why we wrote it that way. Teaching our great law students and advancing scholarship and learning among our students. His titles and achievements are many: co-director of the Intellectual Property Law Program, co-director of the Dean Dinwiddie Center for Intellectual Property Studies, member of the managing board of the Munich Intellectual Property Law Center, co-author of one of the leading casebooks on copyright law, and advisor to the American Law Institute's Restatement of Copyright Project, just to name a few. Professor Braunice's scholarship has had significant impact both in the academy and in the world. Here's one example. An article that he wrote in 2009, Copyright and the World's Most Popular Song, became and remains to this day the most downloaded paper in all time in the Social Science Research Network category of copyright law. That article is formed the basis of a lawsuit that successfully challenged the copyright of the song. Can you guess? Happy Birthday to You, for which he served as the pro bono consultant. Among his many professional achievements, Professor Braunice co-founded the Munich Intellectual Property Law Center in Germany, a cooperative venture between GW Law and 3 German institutions. He served as its managing board, and taught in its LLM program for the past 20 years, during which over 600 students have received degrees and hundreds of US law students have studied. So I could keep going, but you came not to hear his introduction, but his interview of Justice Breyer. So please welcome Professor Braunice and Justice Stephen Breyer.
Well, good afternoon, everyone. Of course, because of the lights, I can't really see you, but I assume you're out there. And good afternoon, Justice Breyer. It's wonderful to have you here, and wonderful to have a conversation, informal conversation with you, with maybe just a few onlookers.
Well, these are the most loyal group of supporters, or either the greatest group of gluttons for punishment. I see a lot of people. I mean, my former law clerk, Gary Katzen, is here. There are others I can't see. Steve Salzberg, who worked on the sentencing guidelines. Those were the days. Right.
Indeed, and some of those days we're going to talk about.
Yeah, yeah.
I guess my mandate is to cover the years roughly 1980 to 1994. So at the last interview, Ken Feinberg spoke with you about the years that ended when you were chief counsel for the Senate Judiciary Committee. And that was sort of towards the end of the Carter administration. And we pick up with your nomination to the First Circuit. And I know he spoke with you a little bit about the process of that nomination, but I thought we would maybe start by delving a little deeper into that. And so what's the story about how you came to be a judge, how you were nominated to the First Circuit?
Good question. I mean, I've been working as chief counsel for the Judiciary Committee, and in the course of that, there was one person nominated as a judge that we began to think as we looked into it. And we usually was both parties, because it was a member of our staff, which on the Democratic side, Senator Kennedy was the chairman, and a member of Senator Thurman's staff. And they'd work on things together. And they'd look into the background and so forth of the nominee. And there seemed to be some difficulties with the background in this particular individual So we thought that they had not perhaps done the vetting that they might have done over at the Justice Department. Before you know it, we went to the senator involved and said, why don't we send it back to the American Bar Association? Mm-hmm. They'll look into it, and if they say he's fine, we'll get him confirmed. And if they say he's not, then it's not your fault, it's the ABA's fault. All right, so no.
Didn't happen.
But he was his campaign manager at the time, and no, okay. So we had a hearing. So Kennedy said, do what you think. That's why we all like Kennedy. You see that? And so Ken and I, before you know it, we had a hearing presided over by Senator Leahy and Senator Hatch jointly. And we brought a certain number of his former clients out of the North Carolina prison where they had been living. Indeed, there were some very dubious things. He represented the head of the cigarette smuggling gang who would always have him plead guilty, make sure that the lower people pleaded guilty, and so blah, blah, blah. Anyway, forget that. What happened next was, because the senator involved was adamant, mm-hmm. And so I sat there at my office and wrote a report about what the hearing had shown and so forth. And the senator sat next to me to be sure I was accurate, which is a little intimidating for a staff person.
I can imagine.
Yeah, and before you know it, the Senate Judiciary Committee did not report him out favorably. Well, the senator wasn't too happy. Then he lost the election. I don't know if that was part of it or not, but then lo and behold, guess what happened? Senator Kennedy nominated me. Well, I mean, it's not me he's angry at. He's angry at Kennedy. And he teams up with a Republican, mm-hmm. And they decide to have a filibuster.
Wow.
So they did have a filibuster. So we had to beat the filibuster, which wasn't that easy.
No.
Ken, he got Senator Ribicoff to call somebody on the floor of the Senate when they were having the debate. Mm-hmm. And so someone shouted out, Senator Abe is calling from Berlin. He said, what do you want? He said, vote against the filibuster. I think he'd been primed to do that. They did have a vote on the filibuster. And we did break the filibuster. So that was up and down. Kennedy would come in and look at me as I was sitting in the office while this is all going on. He goes, see. But we survived that.
But the timing of all this
confirmed.
The timing of all this was particularly extraordinary
because
Carter had lost the election before he nominated you.
That's right.
We all knew that Reagan was going to be president by then, and yet.
Well, what happened? The reason look, if you sit next to a federal judge at dinner, and you want to know how to keep the conversation going, what you do is you turn to the man or the woman, and you say, "How were you appointed?" You won't have to say another word. I mean, that's and of course, everyone thinks that he or she was the only merit appointment ever to have been made. And but we were trying to get Archie Cox appointed.
Uh-huh.
And that had happened a year before, and the Bar Association, he broke some rule on the Bar Association's age limit.
Oh.
And so the president, Carter, didn't want to appoint him. He would have been a great appointment. But then they decided to appoint someone from Puerto Rico, which we thought was a good idea, but they couldn't agree on who to appoint. And before you know it, where we were almost in September, and there was no one nominated. And I think somebody, maybe Ken, I don't know, said to Senator Kennedy, why don't we appoint Steve? This does not sound like a merit appointment. It was. But nonetheless, there we are. And Carter, and really, I think, God, who's his name? But they agreed. They agreed. And so Carter sent my name up, and the filibuster was going on. The Times wrote a nice editorial, and it was Laxalt, really. Laxalt was Reagan's campaign manager, very popular with Republicans, and he came in and voted to break the filibuster. There we are. So they broke it, and I was then confirmed.
So on the other side,
that was an exciting moment. I mean, all those things that.
Of course, it was exciting. I mean, I have to ask, why were you interested in becoming a judge? Now, you had been an academic for a while. You had government service, but government service in the political branches, right? Not as a judge.
Well, I'd worked in the Justice Department when I first. And I'd been a law clerk, and I worked in the Justice Department, and then I worked in the Senate. I taught, and I mean, to me, it was a kind of ideal. I mean, the job for a lawyer, you're doing what you're supposed to do. I mean, it's just you're not. It's not a huge pay, but. You're independent, and you do have to pay attention to each and every case, which is important to somebody, wherever you are. And so you have to give something out. You have to give your best and try to be fair and do your best to be fair and really know the record if you're in the district court or the Court of Appeals. And it's a good job. People like it who are judges, and they feel pleased in the country, to be part of the system of justice. It's all highly idealized, but it's true. and of course, I liked it.
It is a kind of generalist job, isn't it? I mean, you came in, you had certain areas of expertise in antitrust and ad law, and you needed to develop expertise in many other areas. One of the questions we have from students was there any field or issue that you think you learned the most about during this period, so that you'd come in as a judge not knowing about certain areas, maybe criminal law, for example.
Yeah, that's what I was going to say. I had to learn a lot about criminal law, and pretty quickly, too. It's not an easy area of law.
Right.
And so you're both dealing with the human beings involved, and you're dealing with crimes, and it's all over the lot. And so you do have to. I think that is an area that you have to learn about. And of course, in the First Circuit, which I ended up thinking was a great privilege, which I really liked, the First Circuit, for who knows what reasons, consists of Massachusetts, Maine, New Hampshire, Rhode Island, and Puerto Rico. And Puerto Rico is great. First, because you get a really different system of law, because they're part of the civil law world. And they had a great judge down there on the Commonwealth Supreme Court, Trias Monge. And the Puerto Rican status, which is if you want the status in Spanish, it is Estado Libre de Puerto Rico. And they chose that, Estado Libre, the Free State of Puerto Rico, because no one would know what it meant. Perfect. Because they're arguing quite a lot there about status. And the people who wrote the Commonwealth Relations Act were really, it was up here. It was Abe Fortas did quite a lot, and the Kennedys, and Munoz Marin, who was the governor, Pablo Casals, who had a house over there.
I did not know that.
Yeah, And it was the Commonwealth Party, and it's still there, and about half the people vote for the Commonwealth Party, and about half of them vote for a statehood party, and a very small percentage vote for independence. And so it is an argument always. When I first went there, we would go there once a year. And it is not to go there for a vacation. It's not.
It's well timed, though, but that's. I have to.
He was the law clerk, and he had to
exactly.
get everybody
so,
prepared.
I was Judge, now Justice Breyer's law clerk from 1989 through 1991, 2 years, and I twice had the privilege of accompanying you on trips to Puerto Rico, which happened to be in February or so. But yes, it was not a vacation when we were there, although it was nice weather change from Boston at that time of year. So,
and it's interesting. I mean, Munoz Marin got them in the Commonwealth Court to say every precedent is relevant as long as it's not common law or from the United States up here. So I had several law clerks from Puerto Rico, and they would have to come in and they'd have to go look up what the French treatise says or what the German treatise said. And so it was an education. Usually they said about the same thing that we say under our system of law. They just put it in a different language, and they write it in a different style. But it isn't that different. But we still had to learn it.
So that's another area of learning, not just criminal law, but Puerto Rican law and its background was an area that you.
When you got in a bad mood, all the Puerto Rican judges would say, "Well, our code was written by somebody from the mainland who didn't understand a word of Spanish, and somebody they found in Puerto Rico didn't understand any English." And they got together, and well, that's exaggeration, not true, but nonetheless, it was very interesting.
So you're learning how to be a judge. You are learning how to prepare for oral argument. You're learning how to use law clerks. You're learning how to.
And they have to teach me how to be a judge, and that's going to take some time.
And so how did that start to work? How did you come to prepare for oral argument, for example, as we follow the cycle
You would write a memo.
of a case? Write a memo.
And explain it to me.
Yeah, in other words, a clerk would write a memo and explain
Yes.
and explain the case to you.
Correct.
Yes.
And then I'd think about it. And then I would read the briefs. I would, contrary to popular opinion, actually read the briefs and read them pretty carefully. And in the Court of Appeals, they usually weren't so long. I mean, in the Supreme Court, okay. But in the Court of Appeals, you could read quite a few in a short period of time.
Right. Not as many amicus briefs. Not as
Yeah.
And so did you sort of prepare in advance a set of questions?
Yeah, we'd have oral. Did I or not? I mean, we'd have oral argument, and three of us would sit there. It's much easier to have a court with 3 people than it is with 9. I'll tell you try to get 9 people to agree on where to go to lunch, you're going to have a problem. But the 3 people, not so bad. And we'd have a conference after, and opinion would be assigned, and somebody'd write a draft. But and during the big difference, I think, is in oral argument. When you're in a court of appeals, you're in large part trying to find out what does that lawyer think is if it's the appellant's lawyer, what does that lawyer think is the real mistake they made? Mm-hmm. Because what you'll have in the brief is you'll have 15 different complaints. All right, but that lawyer knows the case, and you, the judge, really don't, as well as he does. So get him to tell you what he's actually thinking. What does he think the mistake was, and what does the other side think the answer to that is? And the thing that I learned that I felt was most important, and I would do this sometimes. I can't do it. You really can't do it in the Supreme Court. There are too many people. 9 people is too many. But you can do this in a court of appeals. You put succinctly to lawyer B the argument that lawyer A made. And you say, well, what do you think of that? And then it's interesting, if you do it accurately, and over a period of time you get fairly good at it, the lawyer B thinks you've been fair, even if he loses the case. Mm-hmm. And as long as you understand the other person's point of view, and you see what he says, and he sees that you understand it, and if you put it to the other side, he knows you understand it. And at that point, he's much happier about the justice system.
So this is an opportunity to be heard in a much deeper sense of listening and
Yes.
feeling understood.
Yes, and it works all the time. Yeah, and I tell that to the law students when I'm talking to them. I say, what you're going to do as a lawyer, and what you should do as a person, whether you're a lawyer or not, is listen to the people who disagree with you. And the best you can do is make them understand that you have listened to them. And so don't go into, Kennedy used to say that, I said that before here, that when you get somebody, you have a point of view, you want to persuade somebody. And I found a thing by Lincoln, it's too bad I didn't bring it, a speech that Lincoln gave in the 1840s about, it's called his temperance speech. And it's good. He said, the way you win an argument is before you get into the argument, persuade the other person that you're his friend. You're not his enemy. And you want to hear what he has to say. And then you listen. And what Kennedy used to say is, the more the other person talks. John Stuart Mill said the same thing. He said the first thing you do when you have a point of view that's contentious, you go out and find somebody who's an intelligent person who has the opposite point of view, and then test out what you think. And Kennedy would say, go and listen to that person. Listen. If he or she talks long enough, she'll say something you really agree with. You say, great, let's work with that. And you do, and sometimes you succeed. And then eventually, when it comes time, if you do succeed, that you get some credit, give the credit to the other person. I heard him say, to the press, don't congratulate me, congratulate Senator Hatch. He's the one who thought of this, that got us out of this logjam. Well, I mean, that's just the court. And that's an appeals court, too. Listen. And make sure the lawyers know that. It's not as easy to do as it is to say to do. But it's worthwhile. And I would say that's the First Circuit a lot.
And so does that hold true also for the collegial decision-making process among judges? So now you've heard a case and you're back and you're considering it, you've got three of you, and many cases you don't have a disagreement, but sometimes you do. So how does that work?
Most of the time you don't. Most of the time you're writing opinions, and you ask an appeals court judge, how many opinions does he write during the year? And he'll give you some answer, maybe hundreds or whatever. Say, no. I mean real opinions, where you really have to think your way through it's always around 40-something. And so I thought when I was appointed to the Supreme Court, this will be easy, because they only write about, each judge writes about between 10 and 20 real drafts. No, it isn't easy, because the 10 or 20 are usually the most difficult, even balanced cases that you would have had maybe you've had 2 or 3 of them in the year at the Court of Appeals. But nonetheless, in the conference with 3 of us on the First Circuit, I mean, there wasn't that much disagreement, but there was some. When I first went there, it was Lee Campbell, Frank Coffin. Gary Katzman was my law clerk then. Frank Coffin, Lee Campbell, Hugh Bounds, and me. 4 of us. And Bailey Aldrich was retired. He was a senior judge. Why the Ninth Circuit doesn't want to be split up has always amazed me. It's fun when you have a few people. I mean, it's easier. And you don't have to get into elaborate arguments, and somebody would be assigned the opinion. If it was a record-reading case, you'd wait to have that person read the record and see what he said. And he would go into it with some care. So we enjoyed it. I mean, it was a very harmonious group.
Then Bruce Selya joined later.
Yeah, Torreya joined, I think,
And
next.
Montoya, yes.
Did Selya join next to Torreya? I think Torreya.
By the
I'm
time
not
I was
sure.
clerking, both of them were
Both of them were there.
yeah.
And Torreya was the first circuit judge from Puerto Rico. And he was great. He was a force of nature. He was a very, very good judge, but he was a great sailor. He sailed around Tierra del Fuego. He was the captain of the Puerto Rican sailing team. He was an artist. He wrote, he had pictures that he painted in his office, which weren't pretty good. And he wrote novels, and he was great. He was a good friend. He died recently, I'm sorry to say, but and I said, if anybody, anyway, it was, he was fun. And we go to Puerto Rico, and when we went there, the first thing we'd do is I'd go over to his office and we'd figure, where are we going to go to get some coffee? And we usually went to a place called La Bombadera, which was on the Condado. No, it was not. It was right near the old courthouse. And well, anyway, it was interesting. I liked it. I was there yesterday. I saw we had an event there, and it was like sort of like a coming home. It was nice.
That's great. Let's talk a little bit about the process of opinion writing. How did you go about that, and how did that?
That hasn't changed. That didn't change in the Supreme Court. No. First of all, I mean, assuming a fairly difficult opinion, the law clerk would write a draft, or possibly a memo. I don't care what you call it. Then I would have it. But I'm a former academic, so I would get it, and I would want to make a few changes. And if you are in academia and you write one word, you can't resist writing the second word. And by the time the second, along comes the third, and there you have it. So we'd have my draft come out of the, come out of the typewriter, the word processor, and I'd give it back to the law clerk, and well, she would think hers was better. That happened a lot in the Supreme Court, but nonetheless, she'd think hers was but there we are. What can she do? And so we'd go back and forth with drafts, and eventually get something we'd like, and we'd circulate it. Not different.
I seem to remember that your drafts may have started out in longhand, and maybe they graduated to word processing at some point.
It's possible. Maybe before they had typewriters. And we had, we was in the old courthouse on Post Office Square, and it was not as easy as you might think because it was in not good shape, and the law clerks had to spend considerable time looking for buckets to put on the desk for when it rained. The rain would come in through the top, and oh God, it was a mess. But the sentencing guidelines, I always thought Judge Skinner, who was a good district court judge, sentenced one of the defendants in a tax case, a criminal tax case. He sentenced him to time served in the elevator because the elevator would break down all the time and people would get stuck there. But eventually we got a new courthouse.
I'm sure there are folks in the audience who want to be law clerks, and some of them have been law clerks. How do you think you learned how to use law clerks and interact with them, and how did that change over the time you were on the First Circuit? Well,
say it changed from in this respect. On the First Circuit, it's like a family. I mean, it was really, and I did have one law clerk who kept putting goldfish in the water cooler, and that wasn't you, but nor Gary. But it was that didn't happen in the Supreme Court because I warned them against that.
No goldfish.
Yes, the law clerk is there to help. And the way that since I decide things more by talking them through, it's sort of trying to figure it out, trying different things, trying drafts, maybe it's sort of a mess. And eventually out of this mess arises a case, decision, and an opinion, which we hope is clear and which we hope will explain to people. You can't, I learned fairly quickly that in the Court of Appeals, and probably the district court too, but in the judiciary, you can't prove you're right. What you can do in an opinion, you cannot write the authoritative work that shows how right you are. You might try that, but what you can do is you can write clearly. And you can explain to people why you, the judge, has reached the decision you have. That you can do. People might agree, they might not, but they should be able to understand. And I think that's a lot of the grounding on which respect for the judiciary, which means respect for a rule of law, exists in the United States. It helps. That's what the judges should do. And they do, I think, pretty much in a court of appeals.
Any particular cases that from the First Circuit years that stand out that you remember?
No, they're all over the lot. They were all over the lot. I rather like the case where, again, I like the Puerto Rico cases, and we'd go down. One of them, we had to decide what is the status of Puerto Rico, because in the statute it says, we couldn't say what the status is, but the statute says the laws of Congress will apply to Puerto Rico except insofar as locally inapplicable. What did that mean? And I asked my law clerk at the time, I think it was Doherty, go look it up. And we discovered that that phrase actually came from slavery. and it actually turned into the U.S., came into the U.S. Code because they were going to admit New Mexico as a state, and New Mexico wanted to be a slave state.
Wow.
Ah, yeah, wow. And I guarantee that the people who put that in the federal statute had no idea. That was where the origin of that. So you never knew. Something would be in a case. I was pleased, for example, we had a case. It's interesting. Somebody who worked in one of the bureaucratic agencies said he had been dismissed for a reason that was not a valid reason. Somebody had taken a dislike to him and had dismissed him, and there was no basis for it. And there was a record like this. So I thought, nobody thought he had a case. I thought, I'm going to read that record. And so I did read it. And I thought, he's right. And we ended up deciding in his favor. And I thought, that's what we're here for. That's why people say you can be as rich as you want or as poor as you want. That's why the judiciary, according to Hamilton, really had the power to declare acts of Congress unconstitutional. Because Hamilton says, I think in Federalist 76 or 78 or one of them, he says somebody has to have the power to say when the other branches are behaving unconstitutionally. Otherwise, just take this, take this beautiful Constitution, hang it up in a museum or something. But if the president has that power, he'll just say everything he does is right, or at least too often. If Congress has the power, what about Congress? There are countries that it's the parliament that has the final word. He says, but the trouble is, Congress is very good and really understands popularity. So as long as the person is popular, fine. But you have written a constitution where the most unpopular person in the country is entitled to exactly the same justice as the least popular person. And he says, I'm not so good, I'm not so certain Congress is so good at that. And so we'll have the judges. The judges don't have much power. They don't have the power of the purse. They don't have the power of the sword. They are judges, and this Constitution has something to do with judging. And so we'll give it to them. So I think it wasn't just Marbury versus Madison, and it wasn't just John Marshall. There were a lot of people at that found at the Constitutional Convention who thought that judges would probably have the power to declare an act of Congress unconstitutional. And if Hamilton is to be believed, which he is usually, normally, that was why.
We have a question from a student about circuit splits, and I think that leads to the broader question of, as a judge on a particular circuit, how did you see that circuit as relating to other circuits? How did you interact with
the other circuits on a
circuits?
case where there's no Supreme Court precedent, or of course you follow the Supreme Court if there is, but if there isn't, the other circuits, what were the... Bailey Aldrich. Does anybody know anymore who Bailey Aldrich was? He was a great judge. He was just great. Had a great sense of humor. Very New England. Very New England. I was sitting with him once. He was sitting, and a lawyer in a criminal case was there, and he cited a precedent. He said, well, this really shows my client should win. And Bailey says, what circuit is that from, Mr. whatever? And he was a famous lawyer, too. And he says, that's the Second Circuit. He says, well, you're in the First Circuit now. So that was Bailey. I mean, no. And so you treated them as I have written. I felt you should treat many foreign cases. Read them. You're not bound. But read them with respect. They have similar problems. Try to prevent there from being circuit splits, which I'd say is helpful because it keeps cases away from the Supreme Court that has enough to do. And if they did take your case, as they did sometimes take my case, reverse it. That's what my brother says now when he's a district judge in San Francisco. He says Ninth Circuit takes his case, reverses it. What is it you remember? You remember a program that I saw on television where Vladimir Horowitz was talking to some young students and about where to hear the best concert hall, and his opinion was different from theirs. And he said, that's surprising. He says, let me tell you a story. He says, Charles Munch was conducting the San Francisco Philharmonic. A society lady came up in the interval and he said to her, how do you like the concert, ma'am? She said, oh, I like it very much, but Haydn, she said, I've never really liked Haydn. That's all right, said Munch. Haydn doesn't mind. So I said, and Munch said, you see, that was, and Vladimir Horowitz says, he says, that was her opinion. She's entitled to her opinion. And so if you're reversed by the Supreme Court, the normal judicial reaction of the person who's reversed, maybe they don't say it, that's their opinion. They're entitled to their opinion. And you do your job as best you can.
I'd like to shift topics a little bit to talk about your service on the Sentencing Commission, the initial Sentencing Commission. This was in 1984. You had been then a circuit judge for about 4 years, or 3 to 4 years. And so how did that opportunity arise, and why did you decide to seize it?
Well, Ken Feinberg and the other staff members over the Judiciary Committee worked on this. And we thought at that time it was Marvin Frankel, had written a book. He was a very good judge in New York, and a federal judge who wrote a book saying that the federal sentencing is really out of whack. Why? Because you can get the same person, same kind of person, same kind of offense, and one judge will sentence him to 10 years, and the other judge will sentence him to 2 years. And it's particularly true if they're in different parts of the country, and there shouldn't be that discrepancy, wild discrepancy. And you say, if there's not discrepancy, why do they assign judges in the district court? Why do they assign judges by a wheel? Yeah, seems to make a difference, you see. And also, the sentence given was not the sentence served. The judge would say, 15 years. Well, the parole board would let him out after 5. And so the judge would think, oh, okay, I get it. I'll assign this next one 5 years in jail. And the parole board keep him there for 15. You see, it was who knows what would happen? Wild discrepancies. And there were all kinds of academic studies where they'd give different judges the same pre-sentence report, and you get wildly different sentences. And so the object of the guidelines in the original Federal Code Reform Bill, which was in the 80s or 70s in Congress, was to get a more uniform sentencing system. Not to have higher sentences, not to have lower sentences, have more uniform sentences. And Congress passed it in the early 80s. And I guess Kennedy, since I'd worked on it at the time, thought I'd be a good person on the Sentencing Commission. And Reagan appointed me to the Sentencing Commission. There were 3 or 4 judges, and of course I would do it. And I was chief judge at that time. But it was possible to organize things so we could go down. George McKinnon was on it, Billy Wilkins, and there were 7. And we tried to write a group of guidelines that would achieve the objective. And boy, it went through stages. I think an early draft went through and went around the country and didn't make any sense, frankly, I thought. And everybody who read it thought the same. And so the guidelines got a worse reputation from that than they deserved, because we came back and changed. We changed quite a lot. And eventually we wrote guidelines, got a unanimous commission, and we basically tried, what we did was we tried to take, there were I think 30,000 cases in a computer which had gone through what actually happened, how long the person actually served, and the person was characterized by the pre-sentence report. So for at least 10,000, they knew what that person was like and what he had done, as written in the pre-sentence report. And so we had a fairly good set of computer printouts which told us what was happening for the different crimes in the country on average. And so we tried to follow those in many but not all cases, because people might say, no, this should be more, this should be less. And it worked fairly well, I would not say perfectly. And I think what happened after that is Congress got back in the act, which is not necessarily, from my point of view, a desirable thing, because the point of the guidelines was to get this sentencing more uniform, and it's very hard if you're in a political world to have uniform sentences because you're under pressure from constituents to crime of the day or something. And drugs were coming up as big crimes then, and Congress began to pass mandatory minimums, and that meant the whole point of the guidelines, as is still written right in the first chapter, the whole point of the guidelines was try to get more uniform sentences. So judge, when you sentence somebody, okay, if it's a typical case, you should follow the guidelines. But if you think it's not typical, depart. Don't follow the guidelines. And it says that. And you can depart for any reason you want, not quite. You can't depart for racial reasons. You can't depart for religious reasons. But with a handful of exceptions, you depart. And then you can appeal. And when you appeal, the Court of Appeals should see if what you did was reasonable. In other words, they should probably let you alone, but not 100%. Sometimes they won't. And then the commission should go around and see how the Court of Appeals were doing and what was happening and revise the guidelines accordingly. All right, that was a theory. And you can just tell by the way I can say it, it was really an academic theory. Because then what began to happen is, and I think part of it, there is a temptation in some quarters. You look at a sentence and you say, what should it be? And the political pressure was such at that time in the 80s and 90s. Look at the opinion, look at the sentence, and say more. Politically, you can't get hurt saying more.
Right.
And so when Congress got back in the act, I think part of it was sentences began to go up in the guidelines. And I think it could have been stopped, maybe, by the fact that on the commission there was an ex officio member from the Justice Department, and maybe the Justice Department could have protected the commission from the political pressures that come from a political world. But I don't think I don't know how much of an effort they made. Mm-hmm. Maybe they did and they just couldn't, but I think they're probably in many respects a little high. And then what happened, I say this, and nobody will agree with this in this audience, but I say the legal mind got to work. Now, why do I say that? What does the legal mind like? The legal mind loves, I have it too, so I'm not good, distinctions. We're going to start making distinctions. And so every time we make a distinction, we say over here, this part of the distinction is a little higher and this part a little lower. And before you know it, the guidelines came, just look at the first batch in '86, and it's a book about this thick. And now look at it today. Yeah, so I say that's the legal mind at work. And so if anyone asked my recommendations, which they won't, I would say thinner, fewer, a little more discretion maybe to the judge, and have the department over there trying to prevent the political pressures from, the first thing politically, crack. See, crack, there was a lot of pressure to have big, high sentences for crack. And when the commission sometimes would resist that, and Congress wouldn't, and they passed some statutes that they've had to retract. And now I think finally over in Congress there are movements against mandatory minimums. I'm all in favor of against mandatory minimums, but they can only do it some before they get under too much pressure the other way, but they're beginning to do it. And I thought maybe that would happen for a simple reason. It costs a lot of money to keep people in prison, particularly death penalty. And constituents, they're against crime, and I'm not against that. I think that's fine. But they don't want to spend too much money, maybe. So maybe there will be pressures the other way. So it's a work in progress. Mm-hmm. And if you ask, I say those goals were good, and I'm still in favor of the goals. Greater uniformity, and the sentence given is the sentence served. And give a lot of authority to the district judge, but the typical case should be typical, and the others should, okay, fine. We'll move in that direction. I'd say we've moved since 1986 very slowly in that direction with a certain number of problems along the way. But if I had to vote for it right now, of having this effort at least made by the Sentencing Commission, or not. I would think probably it's in the right direction, as you might say.
So you mentioned uniformity and also so sentence given is sentence served. And then you hear hints of proportionality when you talk about crack cocaine, for example. Were there other cases in which the Sentencing Commission was worried about proportionality? I mean, if you took the average of all sentences given by district judges for this crime and that crime, and then you realized, hey, these two crimes, this one seems much more severe, and yet the average sentence seems to be the
that's why
same.
we look at them. That's why we look at
Yeah.
the thing at the computer printout, crime by crime by crime.
Yeah.
But that's a very hard thing to judge. And you'll get different people with different reactions to that. So you can bring it in, but I think it's safest to go and look at what the judges were actually doing, at least as of that time, and start getting into things about proportion. Fine, no harm. You say it like that, you say, which is I think it's a good idea, but I don't know how much it'll work.
I've heard rumors from various corners that you were considered for the deanship of Harvard Law School at some point while you were a First Circuit judge, and then perhaps later for the presidency of Harvard University. And you evidently did not choose to take up those opportunities.
The deanship? By the time the deanship, that could be, but by the time I was being considered for that, look, I was a judge. And I think I was chief judge probably at that time, I'm not sure. But I can remember my driving back to the courthouse, and the courthouse at that time, was in that Post Office Square building. And you'd open up the doors, which would go creak as you push the button, which had an electric thing. And you'd drive into the basement, and there'd be some number of security officers and some FBI men who were down in the basement, and there were other people, and it really looked sort of, nah. But my thinking was, good. Good. Why? I grew up listening on the radio to Mr. District Attorney. I mean, I grew up listening to Dragnet, but more than that, you're down in the life of the community. And my thought, for whatever reasons, my father was an attorney for the school board. I grew up in San Francisco public schools. So probably I grew up in an area where my family and others would sort of instill unconsciously, at least, a respect for community organizations. I have nothing against Harvard, I'm teaching there now. But to be in the midst of that, to be part of that community, I tried to explain to the students, and, hey, you're part of it. You're part of it. And that I think I liked. I thought that was pretty good. And so when I talk at a graduation, I usually say, I hope for you. What do I hope for you? I hope you'll find someone to love. I hope you will find a job that you enjoy and it's satisfactory for you. And I hope you will participate in the life of the community. Well, this was my way of having an opportunity to do that. And I do think I put weight on that. Derek Bach wrote a pretty good book on education. And he put in that book, I don't know if it's true, but he put in that book that, remember Pericles, the great leader of Athens, I guess in the 3rd century BC or whenever, famous for his funeral oration, where he explained the great things that Athens had, such as democracy, etc. And one of the lines, at least that Derek, I think, in that book said that Pericles said, he said, what do we say in Athens of the man who does not participate in public life? We do not say, he is a man who minds his own business. We say, he is a man who has no business here. That's pretty tough. That's pretty tough. But I want to get across to the students that you're part of a big community here, you know. And so I hope part of your life will be understanding that and participating. Now, was that all in the front of my mind? No. Could it have been there in the back of my mind? Possibly.
So as you kept engaging in the community as a judge, you did, as long as you could, keep teaching some as well, right?
Yeah, I did.
And so tell us a little bit about your continued engagement with teaching
No, I like
as you
teaching.
judged.
God, who would not like teaching? Younger people, they're there. If you can keep them interested, they'll say something interesting. You have a good conversation. You get it. They're not respecters of persons. And I'm a judge. They're not going to, too bad. I better say something that makes sense. And they'll get into conversations. It's great.
And what were you, while you were a judge in the First Circuit, what did you continue to teach at?
Administrative law, probably. And you try teaching administrative law to a young group of law students, they have no idea, nor do I. It's great. It's a good course. It's interesting. You learn a lot about agencies, which hardly anyone likes anymore. But the 14 people who really like administrative law really love it. I used to be.
And you're looking for a 15th.
Yeah, right. That's it. I used to do the Bar Association, had an administrative law section. And Tommy Sussman had a client at that time, before I became a judge. And that client represented all the French champagne in the world. So we'd have our meetings. And anyway, regardless, skip that. But it's fun. I like teaching. Enjoyed it.
You became chief judge in 1990. And I'm curious, I guess, generally, how did you find the job of chief judge to be different than simply being one of the circuit judges on the First Circuit? What additional responsibilities and what different perspective did that bring to you?
Well, I used to say when I was up there, what is it to be chief judge? You get to sit in the middle. And then I'd say the real difference is you have to be involved in administration of the court. And there's a lot to the administration. And administration is something that I found extremely interesting to do and not very interesting to talk about. And it has to work. You have people, the clerk's office. There's a lot of logistics actually involved. And a lot of different things go on. I found that interesting.
In your role as chief judge, one of the things you probably faced that you didn't face as a circuit judge were ethical issues with judges in the circuit. And there's been various discussion about ethical issues in judges recently. I'm curious about how you approached and resolved those issues and what lessons we might draw from that.
Well, in the Court of Appeals and in the district court, the federal system, there are committees that have ethical rules for everybody, and they put them in 7 volumes. I think they used to be. There are a lot of them. And so, if there were an ethical problem that came up, I would read the part and I would try to follow it. And the same. And if you couldn't figure it out, there are a lot of professors of ethics, and you can phone them, which I would do, and see what they said. And you learn pretty quickly which ones always say no, because there are a few of those, and there are some that always say yes, and there are a few of those. And you try to get somebody as best you can who will, say either according to the situation. And that's what I did. And when I became a justice of the Supreme Court, I did the same thing. It's not that tough, you read the volumes. There's even a committee that Margaret McEwen was chairman of recently, which you can call now and find out. And if it's a problem, after you read them. So what I used to do on the Supreme Court, and I think most of the judges do that and did it, is you read the same 7 volumes. And it's about the same. There isn't much difference. And the only difference in the Supreme Court is if you're in a lower court and you decide to recuse yourself, there's another judge to take your place. Judges are fairly fungible. And so it's lean on the side of taking yourself out of the case. You can't do that on the Supreme Court. Right? You can't do it, because if you take yourself out of a case, that changes the number and it could change the outcome. And it wouldn't take too long for lawyers who are interested in that to learn who to challenge an ethical. Please, you don't want gaming in this. But still, the basic idea of using the
The 7 volumes.
The 7 volumes, and asking. That works all right, and it seemed to work fairly well in the Supreme Court. And I suspect, look, I think they ought to do something like that, and I don't know exactly the form it would take, but I put somewhere, I took it out, I found it in my billfold. I took, what did he say? I took what Roberts said, this is the right one. Here, John Roberts said on this, and I'll tell you why I'm quoting it in a second. He says, I want to assure people that I am committed to making certain that we as a court adhere, that's the Supreme Court, adhere to the highest standards of conduct. We are continuing to look at things we can do to give practical effect to that commitment. And I am confident that there are ways to do that, consistent with our status as an independent branch of government and the Constitution's separation of powers. I read that and wrote it down in here some time ago because that's what I think. Exactly. And Justice Barrett has said about the same, I think, and Justice Kagan, and I think Justice Kavanaugh. So it's not easy to work out because there's so many different, 7 volumes is a lot, and you have to see how they would apply in the court, and it takes time, but I think they'll do something like that. That'd be my guess. I don't know. I don't have the inside information, but that's what I would do. Follow what Robert says.
I'd like to talk about one special role that you had in your capacity as chief judge, and that is in the design and construction of what is now known as the Moakley Courthouse.
Oh, I love that. That was
Boston.
fun.
And so, start telling us about how you come to be involved in the site selection, the design process, the construction, all that, and what roles you played.
Well, first we had to get the money for it. Why did we need it? You go up to, I don't know, some of you may have been in that old post office. Gary was, my law clerks were.
Yeah.
And it did rain in through the roof and the window, and people did get stuck in the elevator all the time. It was a fairly good logistical nightmare. So we thought, the judges and probably the bar that was there, they thought we should have a new courthouse. Oh, I'm in favor of that. and there were several parts to this. One was getting the money for it. Well, for some reason, the Congress at some point it had voted $57 million or something for planning and various things. There are volumes of how you build a courthouse, and they have numbers in them. And we needed more money. How were we going to get more money? Well, I had worked in the Congress, and I had, do I admit this? I had friends on the staffs of the committees. And they said, well, they put in some more money for us, but they fully intended to take that out when they got to conference, because the House does it too. And then they meet. And so they did put in more money in the Senate's budget, quite a lot more. And then they all met. And they go through a list. The principals, I don't think, meet too often. I think it's the staffs that do that. And they try to reconcile the House budget with the Senate budget. So they got down to our thing. And the staff from the Senate said, the Senate recedes. We take the House version, which had very little money in it. And but Moakley, it was the congressman and the head of the Rules Committee. And those of you who know the Senate know the head of the Rules Committee. That is an important job in the House of Representatives. It always has been. It certainly was then. And he knew exactly what he was doing. And he was lurking outside the door of the room where they were meeting. And the Senate says the Senate recedes, the staff people. Yep. He opens the door, he goes in, and he says, no, it doesn't. He says the House recedes. And that was it. That was it. There we had enough money to get going on this. It was within the budget. It was within the normal budget for a courthouse of that size. It wasn't an extraordinary amount of money, and it wasn't understated. And it came in within budget, and it came in within time. All right, that's the first part. And then the second part was choosing an architect. Well, there, I found that very, very interesting. So because the GSA, which at that time, it's now an enlightened GSA. And by enlightened GSA, I mean they are interested in architecture, and they want good architecture. Perhaps that was not always the case. And so we would meet with them all the time, and Judge Woodlock and I were interested And that, if anybody wants to build a courthouse or probably any other public building, the way to get it to be nice and attractive and interesting and good architecture and work and be useful and stay within budget and everything is pay attention. That's all. That's all. Probably Woodlock and I met with the GSA over a period of 3 years, once a week.
Wow.
Yeah.
That's a
yeah.
long.
And it's a very interesting. I mean, what public buildings should be like, and the blessings flow on Senator Moynihan, who in fact got a bill passed in Congress once that said, and it's still there, and says that 0.5% of the construction budget will go on art. And that makes a difference. Mm-hmm. All right, so we were interested. And we found some money in a budget that was earmarked for things. This fell within the definition. And we hired Bill Lacey, who was at that time, the secretary of the Pritzker Prize Committee. And he came with us, and we went through the Northwest in our car. We invited GSA. They'd never heard of that. So, but we went to see the work of Pei, Cobb, and Fried. Harry Cobb was the person. We went to see really Caesar Pelli, Moshe Safdie, who had designed the museum up in Ottawa, and Childs from Skidmore, Owens and Merrill, and 5 or 6 good architects. We looked at their buildings, and we asked this question to those: how do you like working in this building? And we wanted to see how the people who had stayed there for a period of time, what did they think? And we learned a lot. And so we finally got through. Vinnie Flanagan, who was a circuit executive, got at least 4 of the 5 architects we wanted through the first cut, and we asked, can we, Woodlock and me, can we sit on the final selection board? And the GSA never had people
Who were interested like that.
Yeah, because we were interested.
Yeah.
And it matters. And they said, okay, sure. So we did. And we said we thought they should film it so future architects would see what we were interested in. And they did film it, but they didn't put film in the camera. And there we are. That's what it was like, I tell you. So we had these people, they had been interested, in plumbing. Those were fine. But the reason we gave this to Harry Cobb finally, and we thought maybe we'd saved Venturi's life, because I don't know how he would have spent 3 or 4 years working with GSA. It's not so easy, but but it's much better now, I promise. Okay, so Harry Cobb says the following. He shows us a slide, and the slide is of a courthouse in Virginia in the 17th century. And he says, look at that 17th century building. Do you see the steeple? There was a steeple. He says that tells people it is a public building. He says, now look at the porch. You see it is a rather open porch, pretty big, and it's going to be in the center of the city, town, village, and people who are not lawyers and not judges will be able to gather on that porch and other buildings. They can talk about anything they want. They can play chess. They can eat their lunch. Perfect. This is a public building. And then the work goes on inside. The judge sits there. There's one courtroom. The judge is sort of part of the furniture. Mm-hmm. The work goes on among the lawyers. And there the public can come in, and there the lawyer. He said, that's what we want. Now, he says, let me show you what happened. It worked all right in the 19th century, because in the 19th century, people followed the Beaux-Arts. And the Beaux-Arts, a big dome. A big dome, public building. Beneath the dome, public space. People can come in and use it for many things. And the courtrooms for opening off the public space, workplaces. And now go look at the courthouse in London, the Strand, same thing. Secular Gothic, what does that mean? It means it looks like a marketplace. The lawyers go back and forth, and they're doing the job, which is what a courthouse is there for. He said, but let me show you Los Angeles. Let me show you Cambridge, Mass. That's their courthouse. You tell me something. Is that a courtroom? Is it a courthouse, or is it an office building? Is it a courthouse, or is it an apartment house? What does it do in this city? It doesn't tell you. And the reason is there are too many courtrooms. He says the challenge is to get a building where you can have your 19 courtrooms, district court and court of appeals, and it looks like a courthouse. And the public can use it. And Woodlock says, and I said, that's what we want. That's what we want. And he spent time, and he spent effort. And the only real public support we had was from the bricklayers, because every part of that building was going to be made in brick.
It's beautiful red brick. It's very
It's beautiful. It's the neighborhood.
local Boston.
It's the neighborhood.
Yeah.
And I still go. I went there yesterday, actually, or the day before. And I said, do you like working here? Yeah, they do like it. And the public can use it. And you look out through these great windows, and there's a park down below where people can use it to have their lunch in the summer, and you can have a band. Great. It's part of the city of Boston. And I once said to somebody who asked me, what is the thing you're proudest of in your life? And I said, helping get that building built. And I said that to Willie Brown, who did the same thing in San Francisco with the city hall and was mayor there. And I said, well, that's what we can be proud of, because long after my opinions are gone, long after, that courthouse will be there. And I don't know if I was understood, but that's sort of how I felt about it. And those of you who are interested, go up and take a look. And Harry got Ellsworth Kelly, who's a great painter. And you look through this, and they're over there, and they're over there. There's one of Ellsworth Kelly's paintings, and you see the color. You see the color in a building that's basically white, and you think, isn't that a honey? That's what my mother would have said. Yeah, okay. And there's no reason you can't do it within budget, on time, if you will put the effort into it. And I'm glad that the two of us did put the effort into that one.
There's a statement on the GSA website that proclaims, at the Moakley Courthouse, more space is dedicated to public use than any other federal courthouse in the United States. So that says it's sort of something good and something unfortunate, right? That your attention to this did
Oh, no,
create
but a lot
space
of good courthouses were built after that. And they perked up and paid attention. And we knew who in the GSA was interested in this and who wasn't. And they began to take an interest in courthouses. And it isn't, they're not bad. This is not unique. And if you want similar examples of trying to get the public in, of trying to see it as their building, you can find that, actually you can find that in Jerusalem. And then you can find that in Bordeaux. You can find that in Melbourne. You can find that in South Africa. In South Africa, they have a great courthouse in Johannesburg. Oh, God, and there they have, you're going into what is like a museum in part, but you walk along this path, which is curved because it's kind of like a village pathway, and over here was the prison where they put Nelson Mandela and others. And it attracts people to be interested in the judicial system, too. Good. Great. You see why I like it? I'm going on too long.
That last statement actually leads into a student question, which was, how did your legal experience influence your approach to courthouse architecture? So how, and...
there are many. Look, you want, and I'll say where you see this. Go to the Second Circuit courtroom sometime. Learned Hand and I think Jerome Frank or somebody helped design it. And what's the key to that? It looks like somebody's sitting room. The key is, which we tried to get as much as possible, and Berger did that here. Look, you want the judge at the same eye level insofar as possible as the lawyer. Why? Because when you're in oral argument, what you're trying to do is to get that judge, which you never succeed in doing, never, but you come close sometimes. You want the judge to forget, the lawyer to forget he's representing somebody. He's a bankruptcy lawyer. He knows about bankruptcy. I don't. He does. And if you can just get him into a conversation, what's really going to happen if we decide? And sometimes you just see it, and it flows, and it works. Not too often, but sometimes it does. In the Supreme Court, in the Court of Appeals, wherever you are. You get into a conversation like that, and you feel you sort of made a little progress. You've made a little progress. And so the eye level of the judge in the courtrooms, Court of Appeals, District Court, in our courthouse in Boston, it's close. It's close. But the main center is not the judge. The center of that courtroom is the lawyers. And they're back and forth. The jury box is over here, and the witness is here, or you. And
I guess the one last thing about the courthouse we haven't focused on is site selection, because it turned out that that courthouse anchored an entirely new neighborhood, right?
Yeah.
That area was not developed at the time you chose that location on Fan Pier, and now it's a fully sort of built out area. So I'm just curious about how it came to be sited there out in Fan Pier.
that's
which
Moakley.
sort of
That's
at the
Moakley.
edge.
That's why Moakley and Mayor White, they were all for the new courthouse, because the area where we put it it was a railroad yard, a beautiful area. I mean, the harbor, you have this incredible view of Boston Harbor, but there was nothing there, nothing, brick, a few brick warehouses, and Moakley wanted it there because he thought it would stimulate development of the area, and it has.
Yes, it
We
has.
were just there, as I said, the night before last, and there was a younger group of people there. One of them, I can't remember who said this, said, this is the it place in Boston. And my God, it may be. And I'm tempted, my granddaughter, when I want to tease her, I said, because I learned the slang from somebody of the 12-year-olds and so forth. You say, what you should say about this area now is, it's Riz. You know what that means? I didn't know. That means if you say...
I hear some appreciative laughter
yes,
from
and you also,
younger parts of members
if
of the
you're really
audience.
careful, that's how I learned this, you have to say W-Riz, which is to say, and you certainly don't say L-Riz, because L-Riz means losing, W means, I learned a lot. You know what else I learned out there? My granddaughter went out of her mind. I said, if she, as she has been known to do, gets up in the middle of dinner and walks into the middle of the dining room and starts doing her ballet or something, no, that's not appropriate. So you look at her like that, and what you say is, Angela, that is bombastic side-eye. So they like that. That means, all right. Anyway.
So I think I understand you have a plane to catch, so I think we have time for one last question. And as a sort of summing up question, there've been 116 justices on the Supreme Court. As you look back, only a little more than 30 of them were circuit court judges before
Really? I didn't know.
They became Supreme Court justices. But the modern trend certainly is to pick from the circuit courts. And I think on the current court, only Justice Kagan was not a circuit court judge for some period of time before she joined the Supreme Court. So I'm just curious, when you think about your time on the First Circuit coming to an end and your time on the Supreme Court starting, what was it about your circuit court experience that you thought informed and was either good or bad as you faced joining the Supreme Court?
Well, the plus is, you know, you've had a lot of experience deciding cases, and you know something about law in different areas, and that's probably helpful. Of course, it's helpful. But having different kinds of experience and different backgrounds and so forth on the Supreme Court, in my own opinion, is a good idea. And you don't have to. There have been senators, there have been governors. There was Warren and so forth. And I think his experience as governor and as a political person was very helpful in desegregation over there. So you don't know what'll come up, and a wide variety of experiences. Okay, that's fine. That's probably good. But the selection process is that of the president. The judges themselves have nothing to do with it. And I think there was one other thought that I had. Well, I think widespread. Well, Thurgood Marshall used to say that. And his experience was different. And it was helpful. And you could. It's a big country. So I knew what I was thinking. I was thinking that for a while, I'm there, I'd say, well, why don't people always agree with me who am so reasonable? I've had a lot of experience in Boston, San Francisco. People seem to disagree sometimes, but here they really disagree. So then I thought, well, it's a big country. It's a big country, 332 or 33 or 34 million people. And you see in that room, this is the Supreme Court, but it's true in the courts of appeals and district courts too. You see tremendous respect, really, for a rule of law, which means people have to be willing to go along with things they don't really agree with. And you see that. You see it, and it's a country of every race, every religion, every point of view, and I've said this a lot, and it's sort of funny, but I'd say, my mother used to say, there's no point of view so nutty there isn't somebody in this country who doesn't hold it. And she'd say they all live in Los Angeles. Remember, we were in San Francisco. But nonetheless, it's not such a bad thing to have people who differ in their points of view, because somehow this law, the Constitution, and the rest of it, it has to, first and foremost, allow these 334 million people to live together in a world that is, as so far as can be, as peaceful, respecting each other's views, as prosperous as we can get it for everybody. And that's why diversity is not so terrible.
That's a wonderful note to end on. Please join me in thanking Justice Breyer.
Thank you. Thank you. Good. Good. Okay. Thank you. Thank you. Very good.
I'm delighted and sorry that these are coming to an end. We've got one more to go, right? Okay, so we're going to have a reception. It's in Tasher, which is on the first floor of the law school building. If you leave out of here and walk across the university yard, we'll meet you there, and so will Justice Breyer. Thank you so much for being here.